The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. We are here today for the submission of two cases. The State of Iowa versus Randy Crawford is hereby submitted without oral argument. And then this afternoon, we are having an oral argument for the case of State versus Retterath. Looks like the parties are ready. You are Jessica Donels, is that correct? Yes, ma'am. You may go first.
May it please the court. Good afternoon. My name is Jessica Donels and I represent Mark Retterath. This appeal is about whether a federally convicted felon, a substance abuser, and alcoholic who is on complete disability for schizophrenia with symptoms of auditory hallucinations can defeat its defendant's statutory right to discovery of impeachment evidence and undermine the legitimacy of this justice system as a truth-seeking body, simply by refusing to waive their privilege over their medical records held by the federal government. This appeal was unexpected. The last time this case was on appeal, the Court of Appeals conditionally remanded Mr. Retterath's conviction for solicitation to commit murder and directed the court to examine the key witness, Aaron Sellers' psychiatric records for impeachment evidence for exculpatory information under the procedure set out in Iowa Code 622.10 4A. When it gave that direction, it expected it would be followed. Probably the legislature didn't anticipate or didn't research the provisions of federal law that permit the Social Security Administration and the U.S. Probation Office from producing these records under a state subpoena without Sellers' consent. But now we are here and we know that Aaron Sellers' records are unobtainable. There is a...
Let's start with that right away. I tell you, looking at the record, I was not impressed with the efforts made either by Mr. Retterath or by the state to get the records out of the federal government. I mean, this is a situation that's not unique to this case. You're a criminal defendant in a state criminal proceeding, and you need access to something that the federal government has. You need to get it out of a federal agency. And my understanding is you go to the federal agency and then you go as far as you can, you exhaust your administrative remedies, and then you have the ability even to go to federal court to try to get the records. And none of that happened here, am I correct?
The record is also in agreement that the parties were in agreement below that the records were not obtainable. There are federal statutes that allow federal agencies to ignore these subpoenas if certain preconditions are not met. And in the case of mental health records, the precondition was Mr. Sellers' consent. That was what was found when the parties attempted to obtain these records below. And actually, the Supremacy Clause of the United States does allow the federal government to override state laws regarding subpoenas in that matter. So that's what happened below.
And this is not unique to this case. This happens in other criminal cases. You know, I found like a case where defendant wanted to get something out of the FBI that in a state criminal defendant, and the FBI wouldn't give it. And then eventually the defendant went to federal court. And that's an accepted route to do that under the Federal Administrative Procedure Act. Here, it looks like both sides just went to the trial judge here and said, "Hey, we can't do anything," and so now we're left with sort of kind of two alternatives, neither of which, on their face, are all that appealing. Either just affirm the case without the records or reverse the case without the records. Why don't we try harder to get the records?
That's certainly a possibility, Your Honor, that more options could be explored. However, with the record as it is, the records are unavailable.
Is the state blameworthy here at all for these records not being in your hands now?
Your Honor, but it's not the state's fault or even the court's fault that these records are unavailable. I mean, this isn't a Brady issue, for example. It's not the state's failure to produce them, but it's their unavailability. This court in State v. Cashin, relying on Pennsylvania v. Ritchie, acknowledged that a defendant has a right to seek impeachment evidence for a witness against him, including privileged mental health records. Now, the procedure that this court set out in Cashin was overturned by the legislature, but the underlying constitutional right and policy concerns underpinning that case are still in place, as recognized by this court in subsequent cases such as Leadham. And so it's not a Brady violation at all, but it is a violation of the statute for which there has to be a remedy.
Possibility of a show cause order versus the witness. Is that something that could have been done in this case? And that relates to Justice Mansfield's question about what efforts were obtained here to actually try to get the records.
Well, under Iowa law, the witness does not have to consent to the disclosure of the records, and that's why we're asking for a sanction of excluding his testimony for a retrial. And we acknowledge that he has a privacy right, but what the solutions that other state courts have come to is when the records are not obtainable in those states because there was no statutory procedure for getting them, unlike in Iowa. If the defendant meets the extremely high showing that the records exist, there is likely exculpatory evidence, it can't be discovered elsewhere, and it's necessary for his defense, these records either get obtained or the witness can't testify.
Why is the state sanctioned here, though? I mean, the state didn't do anything wrong, right? I mean, in a typical situation with Brady or with spoliation or something like that, the state has done something to prevent another party from getting evidence. Here, the state didn't have any role in, at least based upon the argument that I think that you've made here, state didn't have any role in the fact that you don't have these items. And so why punish the state as part of its evidentiary burden?
Really, this is not a case about sanctioning the state, but about protecting Mr. Retterath's trial rights. Mr. Retterath has a right to confront the witnesses against him. He has a right to have the jury see evidence that would weigh on his innocence or guilt. Under the procedure as it shook out in this case, that didn't happen and is not going to happen. This court has held that he has a right to these records, and under the record as it currently stands, barring additional developments, he's not going to have those records. That impacted his cross-examination of Mr. Sellers. It impacted the fundamental fairness of his trial. And so this isn't about sanctioning the state, but it's about protecting the constitutional rights of defendants to have a fair and just trial, and also protecting the integrity of the courts as truth-seeking bodies.
It is about sanctioning the state. So what if you had a fact pattern where the records were destroyed and were no longer available? I assume you would agree at that point that there's no reason to exclude this witness's testimony. Is that right?
That is a completely different scenario, because in that case, it doesn't have anything to do with the witness's actions, with the witness's non-consent. But here the records were not destroyed. Mr. Sellers has refused to consent to their release. He wants to testify against...
So the difference for you is the witness's non-cooperation with the defendant's request. And so in that case, the state should not be allowed to call the witness because the witness isn't cooperating.
That's consistent with this court's case law, which states that being a witness is a duty, and it's not an easy duty to bear, and it sometimes involves discomfort or embarrassment, but nevertheless, it is a duty that witnesses owe to the state and to this court system to truthfully provide evidence.
Well, okay, but counsel, the witness has a right to take the fifth, right? I mean, that's a constitutional right that a witness doesn't have to waive. In a situation like that, you wouldn't say that the witness couldn't otherwise testify, right?
Oh, I think it depends on the scenario, because we don't just have here a witness who's taking the fifth. We have a witness who has given substantial evidence against Mr. Retterath, who's the key witness against Mr. Retterath as the person who Mr. Retterath allegedly solicited to commit murder, the crux of this charge, and who the defendant has gone through the showing of required by the statute to demonstrate that there's substantial impeachment evidence in his medical records. So that makes it different from a case where a witness simply takes the stand and takes the fifth. But also there are ways to overcome a witness who wants to take the fifth. They can be offered immunity and then compelled to testify. So it's not a perfect analogy to this case. What Mr. Retterath is asking the courts to do here is not that unusual. 5 states have independently come to the conclusion that if a witness's medical records are not obtainable and the defendant meets the high burden that Mr. Retterath has met here, the witness should be barred from testifying. In state...
That at trial, even having the deposition where Sellers admitted to having hallucinations and schizophrenia, the defense didn't cross-examine him on that. Doesn't that suggest that the information is not all that important?
No, Your Honor, and this court anticipated this argument in a different case, State v. Niederbach, where a couple were accused of causing serious harm to their child. In that case, the defendant wanted his, either his wife or his paramour, I'm afraid I can't remember, mental health records, and presumably he had a lot of information about her mental health, having lived with her. And he also declined to depose her at the time. And the state argued that that was fatal to his request for the records because he should have already known the information and he didn't depose her to see what she would say. This court rejected those arguments in Niederbach and it should reject them here.
And I mean, you're not shooting blind here if you're the defense lawyer. You've got a deposition where he admits the facts so that if the witness starts hedging or denying, you can impeach him with his own sworn testimony from the other case. And that wasn't even done.
The state argued in Niederbach that Jericho might answer truthfully, but in this court recognized that she also might not answer truthfully. Aaron Sellers might not answer truthfully. He might say he lied in the first deposition. He might say he lied in the second deposition. In both of the depositions, he was vague. He was not very specific on his symptoms. He was not sure what medication he was taking. In Niederbach, this court said the medical records were the best source because they were from someone who was taking notes carefully, who was not just relying on self-report, but also relying on their medical expertise.
Potentially, I mean, would that argue in favor of a post-trial remedy of sorts? So why not let the witness testify, see what happens? If the witness testifies truthfully, as the defendant thinks, it admits to these medical conditions and et cetera, at that point, is there any harm, and why do we need to worry about the medical records?
Well, to answer your question, I'd like to propose the opposite situation. He does not testify truthfully. At this point, the jury's already heard his testimony, and try as we might, it's hard to unring that bell. We do know that he was deposed by defense.
District court then, at that point, make a post-trial ruling, grant him a new trial, and then we'll have to see what happens at that point. Maybe the records become available through greater efforts of the parties. It just seems to me to be presumptuous to assume that the witness can't testify at all because there's a risk that he might testify untruthfully. I don't know. I'm just proposing that to you as a remedy.
It's a fair proposal, but in this case, we already do know from the materials submitted in the confidential appendix that he has testified untruthfully. And it seems fair to anticipate that he would do that again. And for these and the reasons briefed by Mr. Retterath, we respectfully request you reverse the Court of Appeals ruling and affirm the district court's order granting Mr. Retterath a new trial. Oh, yes, Judge.
During your early conversation, the documents are not available. And with the record as it is, the documents are not available. So isn't that the same as that they don't exist? I mean, if they're not there. It just, to me, there's other opportunities where discovery is maybe unsuccessful, you don't gather something. If you are saying it's not available, why do we all of a sudden flip around and say, but we know it is available? I'm confused whether or not you really did take it as far as you could, both of you, or help me understand how both parties went to the mat as far as they could go to gather them. And if not, doesn't the not available mean they do not exist?
I'm running short on time. Can I answer your question? So as far as what the parties did, the record indicates that the state caused subpoenas to be issued to the federal agencies that held the records. The federal agencies said the preconditions for those subpoenas under federal law were not met, and the state indicated that there was no other options to it. At least that's my understanding from reading the record in its representations to the judge. The state was asked to try to obtain consent from Mr. Sellers to get these records. The confidential appendix, I believe, contains an email from the attorney for the state saying, without asking Mr. Sellers, I know that he will not consent. And then Mr. Parrish, I believe, communicated with an administrative law judge who works with the Social Security Administration in an attempt to understand what was needed. This was part of his investigation. This is within the same email in the appendix. And he was informed that what was missing was Mr. Sellers' consent. So, so the first part of your question, what was done, to my understanding of the record, that is what was done. As far as the difference between these records being destroyed in a fire versus Mr. Sellers not consenting to their release, this goes back to the duty that individuals have when they are a witness in the courts. If records are destroyed in a fire, that's no one's fault, unless maybe it's an arsonist's fault, but it's not the witness's fault, it's not the federal agency's fault, it's not the state's fault, it's not the defendant's fault. It's a terrible thing that's happened, to be sure, but it's not someone depriving the courts maliciously or intentionally of evidence which furthers their truth-seeking function to make sure that Mr. Retterath is not wrongfully convicted. That's not what's happened here. Mr. Retterath, the evidence exists. There is a way of accessing it, even though it's not available to Mr. Retterath or to the state at this time. And it's evidence that would be vitally important to serving the court's truth-seeking function. But there's one party standing in the way of that getting done, and it's Mr. Sellers. Thank you.
Thank you, Madam Chief Justice, and may it please the court. Counsel, good afternoon. It's a pleasure to be here. I want to start with a clarification. The state did ask Mr. Sellers, this wasn't just an assumption that he would refuse. He did, in fact, refuse to consent when asked. The state would have preferred to get these records because then a review could have happened and we could have done a real materiality inquiry, but here we are. Now, Justice Mansfield and Justice McDonald, you asked about the efforts that were taken. My understanding is, and I don't have the precise citation, but I read parts of the Federal Register, I believe, and also things on the Social Security Administration website indicating that the precondition, without a release from the patient, the agency considers the disseminating the information to be a violation of HIPAA and also their internal regulations, so they would refuse to do that. Now, I don't know about a remedy under the Administrative Procedure Act, but my understanding is that the applicable standard would be, did you meet the conditions under the agency's regulations for the release? And the condition would be consent of the patient. Even if we had an order to show cause, then we would be in a position of representing that here's a release that was signed voluntarily when in actuality it was signed under threatened penalty. Now, I think all of this is a little bit, I actually agree with opposing counsel that the parties stipulated, not exactly stipulated, but the parties were in agreement that there was nothing more that could be done. Now, if that's in error, if there was more that can be done, that would be great, but.
And I think on the third floor, they would prefer if this could have been worked out in the district court by getting the records. It would save all of us hearing a whole appeal over this one pretty narrow but significant issue. I guess it just strikes me that if you took the opinion of the Court of Appeals, the prior opinion, and as the state, you went to some person of litigation responsibility in the SSA and say, here it is, we need to get these records, that maybe something different would have happened. The impression one gets from the record is just that defense counsel talked to someone he knows at the SSA, and the area prosecutor said, I'm not, at least in the email, said it's not even worth asking because the answer from Mr. Sellers is going to be no. I mean, that's kind of the record in front of us.
I agree that that would be concerning if that was the extent. The transcript gives a more complete summation of what happened, as does the state's resistance. The state caused subpoenas to be issued and served on the Social Security Administration and the Office of Probation and Parole. Those agencies declined to release the records even in response to the state court subpoena. If there's more that can be done, I don't know what the next step would be or what it would. Anyway, the parties have agreed that the records are unobtainable. And so I think, Madam Chief Justice, you're comparing this to a situation where the records are lost in a fire or a flood, or even just a therapist doesn't take notes, that these are unavailable records that are beyond the power of the state court to obtain. And now we're in a situation where, does that mean that the witness just becomes flatly unavailable, unusable in any prosecution? I don't think that's the case. I think that's Barrett, to me, means that in any situation where a court should have done or attempted an in-camera review before trial, when we look at it retrospectively, looking at that error, failure to do or attempt that review, we always include a materiality analysis. What would have been different? Is there a reasonable probability of a different result if not for the error? And here there isn't, because any attempt to obtain the records before trial would have happened exactly this way, would have met the same result. Now, there's an argument that this court should read section 622.10 sub 4 to imply an exclusion remedy, that when the witness could consent to the release of the records and doesn't, then the testimony of the witness should be excluded in its entirety. That's nowhere in the statute. If the legislature intended to create such a remedy, it would have said so. I'd also point out that the idea of a waiver that's legally sufficient under state and federal law is mentioned in other parts of 622.10, specifically in subsection 3, talking about a plaintiff in a civil case where the condition is an element of the claim or essential to a defense or something to that regard. And the patient litigant exception is very carefully drawn. And I believe it's section 5 sets out the sanctions that can be deployed against a patient litigant whose condition is an essential part of the claim, who doesn't sign a release that's legally sufficient under state or federal law. Exclusion by omission, none of those provisions are made part of the subsection about criminal cases, nor are they crafted with words that include criminal cases. They only apply to the patient litigant exception in a civil case.
The right without a remedy, and that troubles me. I mean, there's a right, I take it, I'm sorry if you can't hear me. There's a right, I take it, to these records. They haven't been obtained. And therefore, really, there's no right to the records.
Well, so I think that the right is to, if the records were obtainable, then the right would be to review of the records, not even necessarily to reversal. Since the records can't be obtained, then
The right is a right to obtain the records for purposes of review. But still, this is, I mean, nobody disputes this is a very important witness. Medical records potentially can be explosive. I mean, I'm not saying they are. They could be very plain vanilla for all we know, I guess, at this stage. But this isn't a collateral issue. It does strike me as a very hard case.
well, and this is where I think Brady materiality type inquiry is so important, because I could see a case where Mr. Sellers was the only witness and there wasn't any physical evidence corroborating the things that he said, and where the defendant didn't rely on facts described in Sellers' testimony as part of his own defense. But here, Sellers is just one of the two people who Mr. Retterath solicited. There's the list that Mr. Retterath dictated that Sellers wrote down, then found in Mr. Retterath's pocket. Mr. Retterath's way of arguing against the probative value of his recorded phone call with the victim was to say that cell phone reception at Mr. Sellers' residence was spotty. And he examines Mr. Sellers at trial, draws out, testimony that the cell phone coverage at my place is spotty, and I remember Mr. Retterath, et cetera, et cetera. So all this to say, I could conceive of a situation where a Brady materiality inquiry on a similar situation might shake out differently, but not here. And especially where, as I can't remember whose question this was, but that the defense had a lot of this information that they could have used in cross-examination and didn't. And I think that speaks volumes as to, could this, if the medical records had said the thing that we think there's a reasonable probability that they might have said, or the lower standard required to trigger in-camera review. I disagree, it's a heightened standard. I think it's actually pretty low, as this court has said. If the records had said that, would there be a reasonable probability of a different result if they had been available before trial? And the answer is no, because similar information was available and it wasn't used, and I don't think it would have changed the fact, there's evidence that corroborates a lot of what he said, and there's no other noticeable infirmity. And all of the stuff that was said at the beginning of opposing counsel's argument that cast Mr. Sellers in a negative light, all of that was known and presented during the trial, or a lot of it was, and courts are much less likely to find Brady materiality when it relates to impeachment evidence.
Thinking about how we would do a Brady materiality analysis here. So in the typical Brady case, we know the information that was not disclosed, and we can evaluate after the fact whether that would have made a difference or been material in that sense. But here we don't know. I mean, we're speculating entirely on what these records may or may not say. So I understand what the kind of conceptually what you're arguing, but as a practical matter, how do you weigh the materiality of an unknown quantity, of an unknown piece of evidence?
It's definitely a lot harder than when you have even firsthand testimony about what a destroyed item used to say. But it's not the only time when courts, as finders of fact, draw inferences about the contents of a document that has been lost or has become unavailable. We can get other fact testimony about things that were known, things that are discoverable, to establish the probable or likely, to make it more probable that the records contain useful information or less probable that they do. I don't want to speculate about what that might be, but I also think that to the extent, now see, it's problematic because the requirement of 622.10(4)(a) is that the information not be available from any other source. And that's kind of been watered down a little bit, but in order for that to be applicable, there has to be something qualitatively different about this. So I can see how that could be kind of tricky, but at the same time, it's not as though the inability to get these records could ever create an automatic right to exclusion of a witness's testimony or an automatic right to retrial. I'd just point out one interesting thing about this record is Motion Exhibit A, Mr. Sellers' first deposition, he was an eyewitness to a murder. Now, just picture the situation that we would be in if Mr. Sellers was the eyewitness in a murder. Thankfully, that was resolved by a plea. And the state wanted to call him to testify, but his records were in the possession of a federal agency and became unobtainable to the state court. And so suddenly his extremely probative testimony about a committed murder becomes just entirely excludable just because the witness won't waive the privilege, and there's nothing that really can be done to make that happen.
That we don't think the kind of Brady materiality standard is workable on these facts because we just don't know what's in the record. What would be the state's solution or proposed solution with respect to this witness's testimony? Should it be allowed regardless? Should we just exclude it in the interest of justice?
I think it needs to be allowed. The reason is because, now, when you look at Trammell and Esposito in those cases, their exclusion happens after they've already found a predicate step in the analysis, which is the court has found that there's a risk or a likelihood that allowing the witness to testify on direct without this information being available would violate the defendant's confrontation clause rights. So there's a constitutional violation that they've already found would happen unless you either get the records or exclude the witness's testimony. We're not in that situation here. In fact, we're not talking about a constitutional right at all. We're talking about a statutory right, a statute that doesn't create any implied exclusion remedy whatsoever. And what we're talking about is, I don't think Brady materiality just talks about the contents of the records. It also talks about the trial itself and whether cross-examination of Mr. Sellers was, or whether meaningful cross-examination of Mr. Sellers was possible without access to these records. And I recognize that it's more difficult to do without when the records are unavailable. I don't think that means that we...
In a statement where the witness said, "I'm framing the defendant," I mean, that seems fairly exculpatory.
That would be, but so chronologically that's impossible here, but
Into frame.
I mean, it's theoretically possible that the records contain anything.
I mean, it's a silly example, but we just don't know. I mean, I don't see how you can weigh materiality of something. I understand you can compare the trial record. Maybe you say there's overwhelming evidence of guilt, but you have no idea how to quantify the impact of the record when you don't know what's in the record. I just don't see how that's a workable standard.
I don't think that you can say, I don't think that you can describe it down to the letter, but you can say with a reasonable degree of certainty that this person whose testimony is lucid and remembers details and consistent between the deposition and the trial testimony, that when he gets into his therapist or psychiatrist, doesn't just completely change and become a stark raving mad. That you can, now, I recognize that this is inherently speculative to a certain degree, but it's speculative within a range that you can narrow down by looking at the other facts in the record, by adversarial presentation and development of evidence about what what inferences the court should draw about what they are most likely to contain and the impact that various possible contents would have had on the trial. And that's really where materiality is, about the impact on the trial. Not about what exactly the records contained, but would there be a reasonable probability of a different result in light of all of the rest of the evidence. I see my time's already expired, so unless there are any other questions.
Thank you, Mr. Sloven.
Thank you. I'd like to pick up on what Justice Appel said about the right without a remedy, because yes, the statute is a procedural statute. It lays out the procedure for getting these records, and it doesn't create any constitutional rights. But the whole purpose of the statute was that the legislature did not like the procedural tool that was set out in Cashin, and Cashin was a case that recognized serious due process concerns, serious confrontation clause concerns, serious policy concerns in general if a defendant is not allowed to effectively cross-examine the witnesses against them. And there is a long history of courts recognizing the need for mental health records to cross-examine witnesses. People generally aren't good.
I think counsel distinguished Esposito in those cases on the basis that those cases involved a finding of a confrontation problem. Can you address that, please?
Yes, Your Honor. The finding of the confrontation clause problem in those cases is very similar to the finding that a defendant has to make under the statute here. They have to show that the records exist, that they
Confrontation challenge made in this case?
No, there was not. But the showing is very similar. In these cases and under the statute here, they have to show the records exist, that they're very likely to contain exculpatory information that's not just a fishing expedition. Also, that the exculpatory information is specific to this case. I mean, we're not likely to be getting into a witness's mental health records for something like a simple assault or a drug case. It's very specific to this case that Mr. Sellers was experiencing auditory hallucinations. You know, to pick up on what Justice McDonald was saying earlier, you know, he might have told his therapist that he was intending to frame my client, or he might have told his therapist that I hear voices telling me to kill people. We don't know. But to get back to my point, the showing under the statute is very similar to the showing that was required to be made in those state court cases. What was different about those state court cases is that they don't have the statutory scheme. In those cases, the witnesses had an absolute privilege over their records that they didn't have to waive.
That point in distinguishing those cases, and I didn't quite understand why that difference made, that distinction made a difference.
Do either, Your Honor. Honestly, with the federal records being the way that they are, where they are inaccessible, it has converted our state's qualified privilege into an absolute privilege when the records are held by a federal entity. And that's why we need this solution. We can't have a right without a remedy. We need a way to vindicate the right.
Question about another solution maybe could have been followed. So couldn't Mr. Sellers have been questioned in court under sanctions of contempt, at least asked who his providers were, and then you go and subpoena those providers? I mean, you really didn't want this, you really weren't that interested in what the Social Security Administration had. You wanted that just to get a list of providers.
That is a possible solution that could have been pursued below, and it was not pursued below. I don't know whether it would have been effective. I can't anticipate what Mr. Sellers would have testified to, given his history of conflicting testimony in this case. That's certainly a possibility on remand. Well, lastly, I'd like to go back to the point that Mr. Retterath's trial counsel, and he did have different representation at that point, must not have thought it was very important to impeach Mr. Sellers on this evidence, even though they had it. And the middle school mock trial competition just finished about 2 weeks ago, and the attorneys in that competition, they're about 12 years old, know that you don't ask a question, you don't know how the witness is going to answer. And it makes perfect sense to me that Mr. Sellers was not impeached on these vague contradictory statements in his 2 different depositions, because that's just not a powerful tool for impeachment. This court has already recognized that witnesses are not likely to be reliable narrators of their own mental health. In order to fully and effectively cross-examine, sometimes you need the medical records, and this is a case where the medical records are needed. Mr. Sellers demonstrated he's not a reliable narrator of his own mental health, and in order to effectively put that before the jury, the mental health records were needed. The statute's been violated and a remedy is needed. Thank you.
The case of State versus Retterath is hereby submitted, and court is adjourned for the afternoon. Thank you.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.